Hey, Pepperdine Section B, or anyone else who finds these videos because you have my same professors and need some help. I hope I can help you. So we're Section B, so this is BB the B, and what holds my phone is this really cute penguin phone holder. And this should be my last video, unless I make some Civ Pro ones, but I don't think that's necessary. So, criminal law it is. This is an overview. I'm gonna see if I can get through the whole thing. Can't live stream on Facebook, so I might do this whole thing and then it won't upload. So, fingers crossed. Let's hope it does. Okay, this is Cochran 2019, his criminal law class. So the introduction to criminal law, sources of criminal law, is common law and the legislature, and the constitutional limitations on the legislature are separation of powers, federalism, ex post facto means you can't prosecute in hindsight. The 8th Amendment guards us against cruel and unusual punishment. The 5th and the 14th, as well as the innocence presumed, is the due process clause, and trial by jury is the 6th Amendment right. And then we also are given the law by the Constitution, which trumps all else, says Marbury v. Madison. Okay, so the criminal and the Founding Fathers. Hello. All right, criminal procedure. He says he's not going to test on this, but just to be sure, we have an alleged crime is reported. Fewer than 50% of crimes are reported. Like the person who hacked my Postmates account today and tried to order lunch, and I canceled it. And then they ordered again. Anyway, didn't report it, but I really wish I knew a police officer in San Jose because I totally would like to scare them. Anyway, all right, so alleged crime is reported, police investigate, arrest is if probable cause. Not all things that are investigated lead to an arrest, and not all arrested are charged. I know that hacking my Postmates is not an arrestable offense. I just wanted to scare them. Anyway, then you have a prelim hearing, the grand jury, and the information is filed for formal charges. Then you have pretrial motions or pleading guilty. 90% of cases plea bargain. We're not going to go into how I feel about that. And then we have trial, which includes voir dire, peremptory challenges, excused for cause, the prosecutors make their case. There is a motion for a directed verdict sometimes. Then the defense makes their case. There is jury instructions and closing arguments. And then the jury is usually between 6 and 12. Some need unanimous verdicts. Some need a strong majority. And then conviction or acquittal beyond a reasonable doubt. So we don't find anyone innocent, although they are presumed innocent, but we do acquit them of the charges or we convict them. And that doesn't mean anything. I won't go into that either because that is my soapbox and why I'm in law school. Anyway, jury nullification. Where jury decides to go against what the law says, this is very problematic in places like Jim Crow South during KKK trials. And then a criminal judge cannot direct a verdict to convict, but they can direct a verdict to acquit. Thank you, Jesus. Please, let's have more good judges. And then if someone is convicted, they can appeal, but you cannot appeal an acquittal. Proof of guilt at trial. Proof of guilt at trial is beyond a reasonable doubt. Trial court in portions. So the prosecution presents their case, and that's the burden of production. So they produce what they have of the evidence, and this should establish a possibility. And then the defense motion for a directed verdict, that's them saying the prosecution did not meet their alleged claim. They did not present enough evidence. This is only for the defense. A judge can't rule for the prosecution in directed verdict motion for a criminal trial. So they can they can rule for the trial to go on, but they can't go with the prosecution. Or they can say, yes, the prosecution didn't meet their burden, trial done. I don't know if that happens very often. I doubt it. Anyway, motion is ruled on. If motion wins, D goes free. If motion loses, goes to trial/jury. Now prosecution has the burden of persuasion. So jury nullification occurs when you have a finding of not guilty by a jury in the face of overwhelming evidence. of guilt. So like when a KKK member would be on trial in the Jim Crow South, and they had an all-white jury, and they acquitted him, and he was not. It's a problem. This power can lead to awful results, Klansmen being acquitted when obviously guilty. Yes, we know. Principles of punishment, retributive theories. Retributive theory is punishment is justified because they deserve it. So it's about retribution. Utilitarian theories say justification lies in useful purpose. Punishment serves. There are these bugs. I don't know where they're coming from. So utilitarian justification lies in the purpose of the punishment. So there are some reasons for the punishment. General deterrence deters the group. Specific deterrence deters the person. Incapacitation keeps the person from the risk. And reformation/rehabilitation, it's for society's good and it's for the person's good. And then we have the humanitarian, and they're looking for the reformation, rehabilitation for the defendant's good. So that's utilitarian is for society's good, humanitarian is for the defendant's good. So we have the basic elements of a crime, and they are cause and fact. They're the same as in torts. So voluntary act, cause and fact, proximate cause, harm. Maybe. If it is more than a conduct crime. We'll talk about that in a minute. Then we have attendant circumstances, mens rea, and sometimes specific intent. So sometimes attendant circumstances, always mens rea, sometimes specific intent. Except instead. Anyway, I'm just going to keep going because when there's an exception, I'll tell you. All right, so a voluntary act, that is the actus reus, which is a wrongful action, and it's always implicit in a crime. It's always there. So actus is the action and reus is the result of crime. And this has to be voluntary, which means it needs to be an assertion of will. And if it's not voluntary, ways it's not voluntary is if you're sleeping or unconscious, if you're hypnotized, or if it's a reflex or convulsion, then it's not a voluntary act. So the hypo is illegal entry into the country. If you're shipwrecked, it's not voluntary. But if you're escaping pirates, even though you may have other justifications for why you did it, but it is voluntary to land to get away from the pirates. And then we have acts of omission as voluntary acts. A failure to act equals an act only if there is a duty. So a failure to act will not be a voluntary act unless there is a duty. And there is a duty if, sometimes, a statute imposes. So this can be true for witnesses. Nevada, all people have a duty to act if they see a crime against a child under 7. This can also be imposed by a contractual duty. You've signed up for it. It can be one is volunteered. If you rescue has started and someone is then relying on your rescue, you can't just stop. Although if you try to rescue and no one knows, that doesn't impose the duty. Then we have status that will impose a duty, and that's like parent-child, husband-wife. And there is a duty if the person creates the risk of harm. If you hit a pedestrian with your car, driving off is a crime. And then sometimes people have Good Samaritan laws, which will impose a duty. Some say must act, some say free from liability, so it really depends on the statute. And then we have culpable intent, and that's the mens rea, and that is the guilty mind. So really we always look for actus reus and mens rea. That's what we're going to boil everything down to. And the Supreme Court says the fact that a statute does not specify any required mental state does not mean that none exists. Wrongdoing must be conscious to be criminal. A defendant must be blameworthy in mind before he can be found guilty. A guilty mind is a necessary element in the indictment and the proof of every crime. So, guilty mind. Which means the levels of intent are from highest to lowest: purposeful, knowingly, reckless, and negligent. Purposeful, knowingly, reckless, and negligent. Purposeful, knowingly, reckless, and negligent. So if the statute says intent, then it's going to be purposeful or knowingly. And these are subjective things, but if a statute says malice, or if it's just silent, the default is going to be purposeful, knowingly, and reckless. So you're going to have these three: purposeful, knowingly, and reckless. And purposeful means it's conscious. You're doing it consciously. This is what you're doing it for. Knowingly means practically certain of that result. And reckless means conscious disregard of substantial unjustifiable risk. And here's I don't know if this is backwards for you or not, but that's how it goes around. And then the last one is negligent, and that's an objective view, and this is should be aware of substantial unjustifiable risk, gross deviation from a reasonable person. And for these, a jury can infer the D understands the natural and probable cause of his actions. They can look at the circumstances to get inside his head. So if someone smashes a wine bottle over someone's head, as opposed to a beer bottle over someone's head, as opposed to like a plastic water bottle, like you can, they may all die from blunt force trauma, but there's probably a different intent between a wine bottle and a water bottle. Beer bottle, I mean, it's gray. It's gray. It's gray. And then we have transferred intent. So crimes can transfer to other people, not intended, but they cannot transfer to other crimes in crim law. So if you mean to murder someone and you murder someone else, the intent can transfer. You can't say, oh, I didn't mean for them. Not a thing. And then willful blindness, stop, don't speak, don't tell me. The jurisdictions are split on this. Some say willful blindness is not a thing. Others say the defendant must subjectively believe there is a high probability that the fact exists. The defendant must take deliberate actions to avoid learning of that fact. And the Model Penal Code does not recognize willful blindness. Some state statutes do not. So if you don't know something, you're not going to be held liable for it. But if it's willful blindness, then they're going to say, well, you had intent to not know that. So if you don't know if you don't know a stripper in a club is under 18 but you suspect and you willfully try not to see that, that's like intent to have them there. And then we have strict liability. And so for the Model Penal Code, this is going to be a fine only, because generally strict liability crimes have a modest punishment. So like $100 fine would be okay, but 10 years in prison, probably not. And that's true for almost everything. So when you see this on an exam, you're going to look at the level of a fine and see how that goes. Although we had that on our midterm, and I wrote about it, and that got no points. So I don't know. So the characters of strict liability they're inherently dangerous. You're going to look at what is the custom. Yes, guns are okay, but machine guns are not. They're considered, there's just a different level of danger. Public welfare offenses, which include statutory rape, they could have a modest punishment. They're regulated of trade, or the industry is regulated, like prescription drugs. Statutory rape is a strict liability offense, but does not meet these criterion. So that's pretty well established. Strict liability does not need mens rea. And then we have rules of statutory interpretation. Look at the language of the statute. Look at the legislative intent. Was it based on a code or things intentionally omitted? Look at the legislative history. Look at the statute as a whole. If one part has mens rea and one does not, then we go to intentional, which is purposeful, knowingly, or reckless. You're going to look at case law. Ambiguous penal statute should be interpreted in favor of the defendant. So after you've looked at all of that, if it's still ambiguous, it should be interpreted in favor of the defendant. The one case we had on this did not do that. It was about the mistake of law and taking a gun in. What are you going to do? So then, speaking of, we have mistake. A mistake of fact No excuse unless if it's a specific intent crime, a good faith, genuine mistake of fact, even if unreasonable as to the specific intent requirement. So you'll have an excuse if it was a specific intent crime, but in a general intent crime, a reasonable and good faith mistake of fact as to general intent will also be an excuse. So mistake of fact in general intent, a reasonable mistake will be excused. If specific intent, then if it was a genuine good faith mistake, even if unreasonable, it will be excused. And then mistake of law, no excuse unless there is a reliance on an official statement. Some states recognize mistake of law excuse where D diligently seeks to ascertain the meaning of the statute and in good faith reasonably concludes that his behavior is legal. If it's a duty to act and an unusual requirement, not likely to trigger awareness of a duty. And if it's a specific intent, good faith mistake as to specific intent. So it's more like the general. Because if you have to specifically intend something that you don't know about, you probably didn't specifically intend for that. And motive, which you hear on like Law and Order all the time, motive is not required, but some statutes give heightened punishment for some motives, like hate crimes. We didn't learn any of those. Specific and general intent. General intent means intent to receive, is like intent to receive stolen goods. The culpability required as to the actus reus of the crime. Battery is intentional contact with another. So it's in general. Specific is with knowledge that they are stolen. So if it's a future act, it could be something like with the intent to sell. It's the intent to do something. Specific motive of purpose, offensive contact with the intent to humiliate. Awareness of attendant circumstances, knowing she was 18. So it's specific to a part. So it'll say with the intent or the knowledge, or it'll say. So look at the statute when it's given. And then attendant circumstances in some cases. So some requirement that is thrown into a crime, breaking and entering at night. Here at night would be the attendant circumstance. So it's going to be something added extra to the act. Whereas the specific intent is something added extra to the mens rea. In results crimes, not in conduct crimes. So in result crimes is mainly what we're talking about. Conduct crimes are like a DUI. You were drunk. Most of the time there's not a victim. The victim is society at large is wounded by you in this status. But the results crime is something that has been done. There is a victim. And for that, we need cause and fact. D's act must be cause and fact of the harm. And proximate, so this is more like a tort. Cause and fact, proximate cause, social harm, which is generally always just the harm. And so for that, cause and fact is generally the but-for cause, and it means a substantial factor test. If two factors, either of which, so generally but-for cause. But if there's two factors that could equally have caused the harm, then it's a substantial factor test. And if either of them would have independently caused the harm, then they're both going to be on the hook. So that's the two fires test. And then in homicide, if D's act accelerates the victim's death, it will be cause and fact with some superseding intervening causes, which we'll talk about. Okay, so then we have proximate cause. And proximate cause is what I said earlier about FA-IV, do-IV is my acronym. And FA, foreseeability, A, apparent safety doctrine. When V reaches apparent safety, his decision to return to a position of danger cuts off D's responsibility. If you have any idea that this could be on your exam, write about it. I did not. I still don't think it was there. I should have. Even if I didn't think it was there, it would have got me points. If you're in Cochran's class, just write about it. Then we have intervening factors. So we have responsive intervening factors, and this is the victim avoiding harm, rescue, negligent medical personnel. There will generally be proximate cause here because the defendant still started the whole string of motion. Danger invites rescue, all those things. And then we have coincidental intervening factor. If V is in a roadway and hit by a car, probably foreseen. Chased into a park and then attacked by a gang in like a suburban neighborhood that's not known for that. That's probably not foreseeable. Proximate cause is foreseeable, but no proximate cause if the harm was unforeseeable. So that's fa-I. The next V, fa-iv, is victim's contributory negligence considered as a factor. De minimis causes, but coach said don't worry about those. Omissions of a third party. This is failure to rescue. Even with a duty, it's unlikely to supersede. 5, iv. Intended consequences, unintended manner. So poison you intended the nurse to give your victim poison, but a child gives it to them instead. This establishes proximate cause. And then fa-iv, iv. The last V is the victim's free, deliberate, informed intervention might cut off D's liability. So Jehovah's Witness refusing a blood transfusion. So you cut them and it's bad, but it shouldn't have killed them, but they refused blood transfusion and then they die. That will generally cut off proximate cause. And then last is social harm. This is the injury. In result crimes, there is actual harm to an individual. In conduct crimes, the crime creates a risk to all of us as the conduct is dangerous, hence drunk driving. And now we have all of the different elements. I'm gonna keep going. Okay. So our first crime is burglary, and it's breaking and entering of a dwelling place of another with the attendant circumstance of at night, with the mens rea of with the intent to commit a felony. Breaking and entering of the dwelling place of another at night with the intent to commit a felony. Our next one is rape. And we looked at a lot of different statutes for this. So the one we are using is, the elements are, the defendant had sexual intercourse with the victim did not consent to the intercourse, and the defendant accomplished the intercourse by force, violence, duress, menace, or fear of immediate and unlawful bodily injury. In Pennsylvania, force includes moral, psychological, or intellectual force used to compel a person to engage in sexual intercourse against that person's will. But force is not required in New Jersey, only lack of consent. So you could literally have two people accusing each other of rape, and they could be convicted in New Jersey, which is crazy. And the mens rea for rape is the defendant did not actually and reasonably believe that the woman consented. So those are the elements of rape. The defendant had sexual intercourse with the victim did not consent to the intercourse. The D accomplished the intercourse by force, violence, duress, menace, or fear of immediate and unlawful bodily injury. This is not the case for everywhere. This could be moral and psychological or intellectual force, depending on where you are. Jurisdictions are split, and the mens rea is the D did not actually or reasonably believe the woman consented. Or it doesn't have to be a woman. Anyway, moving on to homicide. Much nicer. Okay, so for plain old second-degree murder or just murder, this is the unlawful killing with malice aforethought. And this includes the intent to kill, which is purposeful. Okay. I'm going to stop there because we're going to want to go over these more. I'm going to stop there.